Hi, this is James Tanner, and this is the ins and outs of probate for genealogists. This is part 5 of a series of short videos on probate and genealogy that are being uploaded to the Brigham Young University Family History Library YouTube channel. This particular segment is called What Are Probate Procedures? First of all, attorneys play a very big role in probate. In the past, attorneys were a rather informal or loose organization of people who represented others in court. There was no real regulation or requirements for becoming an attorney. But basically, back in the old days, over 100, 200 years ago, attorneys represented clients and learned the law through reading about cases. Attorneys would go into a law office and read the law. Of course, this has all changed in the present because now the profession of being an attorney and appearing in court is highly regulated. In addition, we have the judges in the courts. Sometimes we refer to taking a case to court or arguing to the court or whatever. But that just means we're talking to a judge. In some cases, some of the state courts have sort of deputy or vice judges, not judges in charge of vice, but judges that aren't quite as full judge, called commissioners or other titles, to hear probate cases. So you may hear something like the commissioner over probate. Now, historically, particularly in the United States, or earlier in the colonies, probate would have been heard by sometimes by the town council or the leader, mayor of the town. In any event, the court participation in the probate is to decide the law and the facts in the case. The court also enforces the rules and the procedures involved in bringing a case through the court system, and it conducts the hearings or trials as necessary. Now, when we're talking about probate, we have a rather long and involved definition of what a probate is from Black's Law Dictionary. It's actually the act or process of proving a will, but in the event there is no will, then it is the act of settling the estate and applying the law that exists in that state with regards to intestate or succession, or a succession of the heirs without a will. Now, probate law in the United States is based upon English common law. A common law arises out of the cumulative decisions of the courts over hundreds of years. And the probate law in the United States also includes legislature-made statutes and court-made decisions. So the court decisions are persuasive to the court. However, the court must follow the law established by the legislature in statutes. Most of the time when people say something is, for example, against the law, they mean that there is a statute prohibiting the action. However, that does not apply to civil cases. So generally speaking, something in a civil case would not be against the law. It would just be the ruling of the court that what was requested by the attorney or the client in the court would not be consistent with what the law provided. In any event, all of the law in the United States is based on a procedure called stare decisis, or precedence. That means that previously decided cases are persuasive and sometimes controlling in the way that the court decides a subsequent lawsuit. Now, it's important to understand that some procedures change, but some don't. So a probate action is started by the petitioner filing a probate petition with the court that includes a copy of the will if one exists. And then the petition asks the court to open a testate action with a will or open an intestate action. Now, this particular procedure has not changed for hundreds of years, and there are 5 major steps in a probate that have also not changed for hundreds of years. The first of those is the filing of the probate petition, either with or without a will. The second is the administration of the estate. That means that an administrator, person who is going to act, sometimes called the executor if there is a will, and then there is those that individual acts and does an inventory of the estate, accounts to the court for the payment of any of the bills of the estate, and then closes the estate and distributes the assets if there are any remaining. Now, for genealogical purposes, there's some things that we need to understand about probate. The first of these is the need to know some of the terminology. Not all of the terminology. There are only a very limited set of terms that the genealogical researcher really needs to understand. The second is the need to know some of the law in the state or area that's being researched. This is what we would call black letter law, or law that is written down according to the legislature. And of course, these have changed over time. Obviously, during the colonial era of the United States, the law was purely British. And after the country was established as the United States of America, the United States began enacting the legislatures began enacting their own set of laws. There's also a need to know some of the procedures of the court. So now we need to know the difference between the law as it is and the procedures. So what are probate procedures? First of all, we understand that laws are made by the legislature. Rules are made by administrative agencies. So, for example, here, the United States legislature would pass a law, and then an administrative agency, such as the IRS or any of the regulatory commissions or whatever, will make rules about how that law is to be implemented. Then, apart from that, and completely separate, are the procedures that are enacted by the courts, the judges, as to how their trials and their cases will proceed in their courts. So what we have, generally speaking, throughout the United States are rules of civil procedure. These are rules that act as a roadmap on how to conduct a lawsuit. Now, learning the law is complex enough, but learning the procedure about taking a case through court, such as a probate case, can become one of the most challenging things that attorneys have to learn as they go through the process of becoming certified. And it's important to understand that the rules of civil procedure vary from court to court, and county to county, and from state to state. So it's not easy for an attorney to move from one state to another. And in some cases, they may have to learn a whole new way of approaching the law and the way that the courts handle the cases. In addition, the rules of civil procedure change frequently. When I started practicing law now more than 40 years ago, the whole book of rules of civil procedure was approximately half an inch thick. By the time I finished, it was closer to 2 inches thick. So the rules of procedure have become much more complex and more difficult to learn. And surprisingly, the rules of civil procedure, not the law, can be often determine who wins or loses in the case. Many times the cases are won or lost in the procedures, not in the actual trial of the case. Now, how do we distinguish between procedures and the law? Just remember that procedures determine what happens in court, what actually goes in, what documents are filed, the order of the filing, what happens at the time of the hearing, what the court is supposed to decide. All of those things are the procedures. The laws that, on the other hand, determine how the judge or the other magistrate decides the case. So the court has to decide the case based on the law, but the case doesn't come before the judge for a decision except through the procedures. In addition, the parties to a probate must follow both the law and the procedures. Now, since all of this exists, a genealogist is sort of caught in the middle of this whole circumstance, because in order to read an old will case, a probate case or an old will, it requires that researcher have at least the basic understanding of what is going on. Who won, who lost, who got what, if there was a contest, what was the contest about. All of these kinds of things have to be understood in order to understand what happened in the history of the ancestor and going through a probate. And sometimes I have to admit that the differences can be baffling between law and procedures. I was constantly explaining to clients that there was a difference, but I don't think many people completely understood what I was talking about. So when we're talking about probate law, when we say, oh, we're going to worry about what the probate law was, what we're usually talking about are the probate procedures. The genealogist would be much more interested in the procedure of the court than they would in the actual law that made the determination as it was. It's the procedure that creates the documents, by the way. Important to understand also that probate procedures have changed very little in historic times. So you go back 200, 300 years and look at a probate proceeding, it will be very recognizable as almost the same as one that you would see today. The format of the petitions, of course, have changed. Not the wording, but the actual way they're put together. And the time periods for filings have changed. Obviously, the courts would like to see the cases move through their court and be finalized. Today we have rules that provide for certain things to happen during certain time periods. Of course, the number of copies that have filed has been changed. In the past, there was only one copy. It was very difficult to make an additional copy unless the court had someone sit down there and copy by hand any of the documents. And, of course, the formalities of going through court have changed. Important to understand that probate is a lot more than just filling out blank form on the forms. Now, this particular segment is a part of the longer series. There will be a total of 9 videos in this series, and I encourage you to watch all of them in succession so that they make some sense. Thanks for watching.